All right, let's quickly take you back to the High Court in Johannesburg now, where we find judgment being handed down in terms of Ntuthuko Shoba, his application for leave to appeal his conviction and sentence. This is for the murder of his girlfriend, Ntuthuko.
And recognise Mr. Malapane when the two men were outside the complex gate. The stills from the CCTV footage show that Mr. Shoba was outside the gate for no more than 2.5 to 3 minutes, and that he was some distance from Mr. Malapane's jeep. In light of this, Mr. Barnard submitted that it was at least reasonably possible that Mr. Shoba could not have seen or recognised Mr. Malapane as the driver. The problem with this argument is that it misconceives what I made of the incident in my judgment, and it leaves out of account some important aspects of the evidence about that incident. I did not conclude in my trial judgment that Mr. Shoba must necessarily have been close enough to the jeep for a period long enough to see and recognise Mr. Malapane. I first noted that Mr. Shoba accepted that there had been a conversation between Miss Pule and Mr. Malapane. I concluded that Mr. Shoba must have recognised Mr. Malapane's voice. On Mr. Shoba's own version, the two men had met several times before, had known each other for 10 years, and had recently had a conversation calling car to car while stationary at a robot on Main Reef Road. Moreover, Mr. Malapane had turned up late at night, drunk, to ferry Mr. Shoba's pregnant girlfriend away. Mr. Shoba accepted that he was close enough to the jeep to hear Miss Pule tell Mr. Malapane that he was sloshed. Mr. Shoba presented himself at trial as a caring, expectant father. In these circumstances, I found that, had he genuinely been unaware of who was driving the jeep, Mr. Shoba would have shown some interest in the identity of the person who had arrived to pick a woman up, carrying his child, late at night in a state of inebriation. I concluded that, in light of the totality of the evidence, the only reasonable explanation for Mr. Shoba's lack of interest is that he knew all along that Mr. Malapane was the driver, and also that he knew what Mr. Malapane was going to do after he drove Miss Pule away. The fact that the stills from the CCTV footage show Mr. Shoba at a distance from the jeep, apparently making no effort to see who was inside, simply begs the question. Mr. Shoba need have made no effort to see and interact with Mr. Malapane if he knew why Mr. Malapane was there and what he was going to do when he left with Miss Pule. I am accordingly unable to accept that there is any prospect of an appeal court finding reason to doubt Mr. Shoba's guilt in the fact that, on Mr. Shoba's version, he was not close enough to the jeep for long enough to recognise Mr. Malapane. The second leg of Mr. Barnard's argument concerned my rejection of Mr. Shoba's explanation for his contact with Mr. Malapane in the weeks leading up to Miss Pule's murder. Mr. Malapane gave evidence that he met with Mr. Shoba to arrange Miss Pule's death, and that he had no other reason to do so. Mr. Shoba said that he contacted Mr. Malapane to procure an illegal supply of cigarettes during the ban on their sale under the COVID lockdown regulations, not to arrange a contract killing. Mr. Malapane testified that he did sell alcohol illegally during the lockdown, but that he did not sell cigarettes. Mr. Kamalo, a friend of Mr. Malapane and Mr. Malapane's former partner, both corroborated this. Mr. Malapani's former partner stated categorically that had Mr. Malapani been involved in selling cigarettes from the home that they shared, then she would have known about it. Mr. Barnard pointed to a passage of Mr. Malapani's evidence in which Mr. Malapani equivocates about whether he could have sourced cigarettes for sale if he had wanted to. Mr. Barnard pressed the conclusion that this tainted Mr. Malapani's evidence on the separate question of whether he actually did sell cigarettes. But that conclusion does not follow. There was, it is true, a degree of inconsistency in Mr. Malapani's evidence about whether he had access to cigarettes. Mr. Barnard accepted, however, that Mr. Malapani was clear and consistent on the point that he did not actually sell cigarettes to Mr. Shoba or anyone else. I am unable to conclude that Mr. Malapani's equivocation on whether he could have sold cigarettes had he wanted to taints his version that he did not actually do so. Mr. Barnard asked me to accept the possibility that Mr. Khumalo and Mr. Malapani's former partner were mistaken in believing that Mr. Malapani did not sell cigarettes. Now, apart from the fact that neither of these witnesses' versions was challenged during the trial, I find it particularly difficult to see how I could have rejected the evidence of Mr. Malapani's former partner. She lived with Mr. Malapani. She knew him and his dealings intimately. Mr. Shoba says he went to buy cigarettes at the house she shared with Mr. Malapani. She plainly would have known if cigarettes were being sold from her home. I am unable to accept, therefore, that there is any prospect that an appeal court will find that I was wrong to accept Mr. Malapani's evidence that he never sold cigarettes, and to reject Mr. Shoba's evidence that he visited Mr. Malapani for the sole purpose of buying them. The third main argument Mr. Barnard advanced involved criticism of the state's failure to investigate the phone number that was used to send some threatening text messages to Miss Poulet in the weeks leading up to her murder, and the phone number that was used to send the text messages that invited Miss Poulet to attend an interview at the McDonald's in Ormond. These text messages were not sent from the 081 number that the state said Mr. Shoba used to communicate with Mr. Malapani. This, Mr. Barnard argued, was an anomaly that required further examination. Now, I accept that there was no evidence presented at trial that either of these numbers was investigated. But it was common cause at trial that the state did investigate the possibility that Mr. Malapani was connected with Miss Poulet other than through Mr. Shoba. It was equally common cause that this investigation came up with nothing. Wherever the threatening text messages came from, the critical question was whether Mr. Malapani had some undisclosed motive for killing Miss Poulet other than the implementation of a contract with Mr. Shoba on Miss Poulet's life. Mr. Shoba's defense team did not criticize the state's investigation of that issue in any way. In those circumstances, I cannot conclude that there is any prospect that an appeal court will find reasonable doubt in the state's failure to present evidence that it investigated the number from which the threatening text messages were sent, or the number that issued the invitation to interview at the McDonald's outlet in Ormond. Ultimately, none of the arguments that Mr. Barnard advanced offered the prospect of a coherent and rational account of the totality of facts established at trial that would have left room for reasonable doubt of Mr. Shoba's guilt. The first and third arguments would not have done so, even if they were right on their own terms. The second argument might have, But the fact remains that there is no reason to suspect that an appeal court would reject Mr. Malapani's version that he did not sell cigarettes, especially as it was corroborated by the unchallenged evidence of 2 other witnesses. Perhaps sensing this difficulty, Mr. Barnard emphasized the profound consequences that this trial has had for Mr. Shoba. He emphasized that I was the sole trier of fact and of law in a process that has led to Mr. Shoba's committal to prison for the rest of his life. Mr. Barnard asked me to consider whether I ought to grant leave to appeal in order to ensure that a process with such profound consequences is subjected to appellate review. A judge sitting alone in any criminal trial bears a heavy burden. Where the trial has resulted in the imposition of a life sentence, that burden is particularly acute. Throughout these proceedings, I have been keenly aware of the possibility that I might make a mistake, and that the consequences of my doing so for all involved would be particularly severe. Given these very high stakes, Mr. Barnard's submissions may count strongly in favour of an unqualified right to appeal for those convicted of a crime for which they then receive a term of life imprisonment. However, that is not the law. The primary question before me is whether there is a reasonable prospect that I was materially mistaken, either in putting together the evidence that led to the conclusion I reached, or in applying the law to that evidence. Only the prospect of a mistake of that nature would ground prospects of success on appeal. If Mr. Shoba's prospects were weak but arguable, I might have been persuaded that given the consequences of my decision for him, I should grant leave to appeal, even if I thought the appeal stood only a remote chance of success. Section 17(1)(a)(2) of the Superior Courts Act 10 of 2013 allows for this course to be taken. It accepts that an appeal with few or no prospects of success may nonetheless proceed if there is some other compelling reason to allow it to do so. But on the material before me, I cannot conclude that Mr. Shoba's prospects of success rise even to the remote. In those circumstances, there is no sufficiently compelling reason to grant leave to appeal. To do so would be no more than an exercise in judicial vanity, and one which would only lengthen the dull, dragging agony that these proceedings have no doubt imposed on Miss Poulet's family and friends. No substantial argument on the prospects of an appeal against sentence was directed to me. I put to Mr. Barnard that if I was right to convict Mr. Shoba, then I must have been right to sentence him as I did. Mr. Barnard offered no riposte. For all these reasons, the application for leave to appeal against both conviction and sentence is refused. I hand down the judgment. Mr. Mohammed, is there anything else? Yes, thank you both for your assistance. The court is adjourned.